copies of those already prepared that you may pick up in the press packet. If you would like to have us email those to you, if you would supply us with an email, we'll be happy to do so. On Wednesday, April 21st, 2021, Andrew Brown Jr. of Elizabeth City, North Carolina, was shot and killed by 3 deputies with the Pasquotank County Sheriff's Office. This incident occurred at the residence of Mr. Brown, located at 421 Perry Street in Elizabeth City, North Carolina. After reviewing the investigation conducted by the North Carolina State Bureau of Investigation, Mr. Brown's death, while tragic, was justified because Mr. Brown's actions caused 3 deputies with the Pasquotank County Sheriff's Office to reasonably believe it was necessary to use deadly force to protect themselves and others. While the officer-involved shooting that resulted in the death of Andrew Brown occurred on Wednesday, April 21st, law enforcement involvement with Mr. Brown began in the weeks prior and put the wheels in motion that eventually led to the attempted service of arrest and search warrants on April 21, 2021. In the early months of this year, Detective Johnson with the Dare County Sheriff's Office received information from a reliable confidential source that Andrew Brown Jr. from Elizabeth City was selling drugs in Dare County. Detective Johnson contacted Pasquotank County and confirmed Mr. Brown's identity and that he is a known drug dealer. Upon learning this information, Detective Johnson, with the aid of the confidential informant, made 2 undercover buys from Brown on March 17, 2021 and March 29, 2021. Those buys were of cocaine and heroin, respectively. A later SBI lab analysis determined that the heroin was laced with fentanyl. Subsequently, arrest warrants were issued for Brown's arrest on April 20th, 2021. Simultaneous with the activity of the Dare County Sheriff's Office, Pasquotank County Sheriff's Office began collecting their own intelligence on the drug activity of Mr. Brown at his residence at 421 Perry Street. Detective Ryan Meads applied for and obtained a search warrant for the residence and vehicles of Mr. Brown. On Tuesday, April 20th, 2021, law enforcement now possessed 2 arrest warrants for the sale of controlled substances in Dare County, as well as a search warrant for the residence and vehicles of Mr. Brown. A joint team of law enforcement from Dare County and Pasquotank was assembled. The Dare County Drug Task Force was to provide surveillance, and the officers present that day were Detective Johnson, Sergeant Ruth, and Detective Langley. The Pasquotank Special Operation and Tactics team would serve the warrants and take Mr. Brown into custody. Their team consisted of Lieutenant Judge Sergeant Meads, Deputy Morgan, Deputy Llewellyn, Deputy Bishop, Deputy Swindale, and Deputy Lunsford. Deputies Morgan, Llewellyn, Bishop, and Swindale were wearing body cameras. Their original plan was to serve the warrants on the night of April 20, 2021. However, Mr. Brown was not at his residence and could not be located by the surveillance team. On the morning of April 21, 2021, at approximately 5:30 a.m., law enforcement held a briefing here at the Pasquotank County Sheriff's Office and planned to serve the warrants on Mr. Brown. During the briefing conducted by Sergeant Meads, the team was briefed on Mr. Brown and his past involvement with law enforcement. It was relayed to the team that Mr. Brown has multiple resist arrest charges and convictions dating back to 1995. Additionally, Mr. Brown has assault with a deadly weapon, and assault inflicting serious injury convictions dating back to 1995. Further, Mr. Brown has barricaded doorways during previous home search warrant instances. No children were believed to be at the location, and the mother of Mr. Brown's minor children was seldom at his residence. At approximately 8 a.m., Mr. Brown was located on Speed Street here in Elizabeth City by one of the members of the Dare County narcotics team. Mr. Brown then drove his vehicle to his residence at 421 Perry Street and remained in his vehicle until law enforcement arrived. Upon receiving this information, the Pasquotank County team traveled to 421 Perry Street to serve the warrants in a clearly marked Pasquotank County Sheriff's Office truck with blue lights and emergency lights flashing. Detective Langley from Dare County drove the vehicle, and Deputy Lunsford was in the passenger seat. The remaining members of the Pasquotank County team were in the truck bed as the truck was en route. Upon arriving to 421 Perry Street at approximately 8:23 a.m., Mr. Brown was still sitting in his vehicle beside the residence. Detective Langley pulled the Pasquotank County truck in the driveway with his right front bumper close to the front bumper of Brown's vehicle to block any forward motion, and Brown was still seated in the vehicle. The 6 members of the Pasquotank County team approached Brown's vehicle, identified themselves, shouted commands to show them his hands and to exit the vehicle. All members were wearing clearly marked Pasquotank County Sheriff's Office gear and uniforms. Deputy Lunsford headed directly to the driver's door with his weapon drawn and attempted to open the door. Deputy Swindale accompanied Deputy Lunsford to the driver's side of the car. Deputy Llewellyn went around the Pasquotank County truck and approached the vehicle from the front passenger side, and Deputy Bishop Would you like to do this manually? Deputy Llewellyn went around the Pasquotank County truck and approached the vehicle from the front passenger side, and Deputy Bishop and Sergeant Meads were directly in front of Brown's car. Deputy Morgan approached last and positioned himself between Deputy Bishop and Sergeant Meads. Nothing ever works the way it's supposed to, does it? If you'll just be patient. I want you to have a full, complete, and accurate view of what transpired and what the deputies saw that particular day. Right there, stop. Once again, I will repeat. You're looking at Deputy Llewellyn's body cam, and he went around the Pasquotank County truck. He approached from the passenger side. Deputy Bishop, Sergeant Meads were directly in front of Brown's vehicle, and Deputy Morgan approached last and positioned himself between Deputy Bishop and Sergeant Meads. Brown was holding his phone when law enforcement approached. You skipped. Can you back up? Back up. All right. Brown threw the phone down and began to rapidly back his car away from the officers. Have you taken it out? Am I completely offline at this point? You need to back up to about 5 slides. If you'll leave it right there. You're at photo 11. If you would back up to photo 6. All right. Thank you. Andrea, at this point, I will just give you the nod to move forward, okay? Brown threw the phone down and began to rapidly back his car away from the officers. Deputy Lunsford's hand was still on the driver's door handle as Brown's car reversed and the handle was snatched out of his hand. At this moment, Deputy Lunsford yelled out, and Deputy Lunsford was pulled over the hood of Brown's vehicle where his body and his safety equipment were struck by the vehicle. Deputy Lunsford's left arm was squarely on the hood. Deputy Lunsford took evasive action to get out of the way of the front left tire of Brown's vehicle, and law enforcement commands became more heated with profanities shouted for Brown to stop the car. Brown ignored the officer's commands and backed his car until he was blocked by the rear of his residence. Continue. Continue. Right there. Brown then put the car in drive and turned the steering wheel left directly at law enforcement officers who had now surrounded his vehicle. Despite this tense situation and the aggressive driving by Mr. Brown, no law enforcement officer fired a shot. As Brown's car starts forward, Deputy Lunsford was now positioned directly in front of the vehicle, and all officers were shouting commands to stop. Brown ignored the commands and drove directly at Deputy Lunsford. Deputy Lunsford used his left hand to push off of the hood. It was at this moment that the first shot is fired. Deputy Lunsford then spun out of the way to avoid being run over by Brown's vehicle. One more. According to the North Carolina Justice Academy forensic analyst Cason Reynolds, the first shot was fired by Sergeant Meads, and it entered the front windshield of Mr. Brown's car. Let me say that again. It entered the front windshield of Mr. Brown's car. Brown's car continued forward, passing Deputy Lunsford, Deputy Morgan, and Sergeant Meads, and several shots are heard. One shot entered the passenger window and struck Brown in the shoulder. Several more entered the rear passenger side door and window. Brown's vehicle then accelerated across the vacant lot next to 421 Perry Street, and 5 additional shots entered the rear windshield and trunk of Brown's vehicle. At this moment, Brown was driving directly at Investigator Johnson, who was positioned on Roanoke Avenue in an unmarked white van. Lieutenant Judd was positioned on the corner of Roanoke and Perry in an unmarked white Crown Victoria. Brown's car narrowly missed striking the van operated by Investigator Johnson, who accelerated to avoid the collision. Brown's vehicle crossed Roanoke Avenue and struck a tree in the residence on Roanoke Avenue and came to rest. The Pasquotank County team gave chase, removed Brown from the driver's seat, and life-saving efforts were immediately begun. At 8:24, deputies notified dispatch of shots fired. Emergency medical services were requested at 8:26 a.m. Lieutenant Judd was the supervising officer. He was on the scene at the time of the shooting. Other supervising officers of Pasquotank County Sheriff's Office arrived, including Chief Deputy Fogg, who collected the weapons and cell phones of the officers who fired. All of the following is clearly depicted on the body cameras that were operational and functioning properly on April 21, 2021. They were being warned by the aforementioned Pasquotank County Sheriff's officers. The total length of officer involvement with Mr. Brown from the time they exited the vehicle until Mr. Brown was removed from the vehicle is 44 seconds. I'm now going to show you the 4 body cam videos that depict law enforcement activity with Mr. Brown on that day.
Go, 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 go!
approximately 9 o'clock on April 21, 2021, I received a call from Special Agent in Charge Michelle Rogers with the North Carolina State Bureau of Investigation informing me of the officer-involved shooting. Sheriff Tommy Wooten and I jointly requested the SBI conduct a thorough investigation of the shooting. Shortly after speaking with Special Agent Rogers, I contacted District Attorney Investigator John Young to meet me at our office here in Elizabeth City and to proceed with me to the scene of the incident. We viewed the scene, and later that day I met with Sheriff Wooten, Special Agent Rogers, members of the SBI team that would conduct the investigation. On May 11th, 2021, the SBI lead case agent, Jason Godfrey, began releasing the SBI report gathered to the District Attorney's office. I immediately began review of the written SBI reports and other documents as investigated by the SBI. I reviewed the SBI investigation, which included interviews of the deputies involved with the Pasquotank County Sheriff's Office, interviews of civilian witnesses, interview of Dr. Karen L. Kelly, a forensic pathologist at the Brody School of Medicine at East Carolina University in Greenville, photographs of the scene, ballistics and trajectory report of Cason Reynolds, analysis of weapons and shell casings, the law enforcement personnel records of the deputies involved, video footage of the body cameras at the scene, and the crime scene report. In addition, I have met or had telephone contact with Jason Godfrey practically every day since April 21, 2021. Agent Godfrey and I viewed the trajectory rod analysis performed by Agent Candace Pegram and assisted by Agents Rob Evans and Stephen Stile on April 22nd, 2021. Further, I sought advice and counsel from numerous elected district attorneys around the state who have had recent experience with officer-involved shooting cases. There are 14 houses near 421 Perry Street, and each location was canvassed for evidence and witnesses. 4 civilians provided statements to law enforcement. Ms. Demetria Williams stated she lived in the vicinity of 421 Perry Street and heard gunshot from inside of her residence. She further stated that after hearing the first shot, she exited her home, went down the street, and saw the remainder of the shots being fired. Ms. Williams' home is approximately 100 yards away from 421 Perry Street. The total elapsed time from the first shot to the last is 5 seconds, calling into question Ms. Williams' statements regarding witnessing the shooting. The second civilian to give a statement was Daniel Sturdivant. Mr. Sturdivant stated the incident occurred prior to 8 a.m. He stated he heard officers shouting commands, at which time he walked to his window. Sturdivant stated the officers were firing into the car while they were giving Brown commands to get out. The third civilian to give a statement was Ashley Bechtel. Ms. Bechtel stated she did not see the initial shots fired, but heard them and went to her window. She stated Brown's car was heading over Roanoke Avenue, and the officers were forceful when removing Brown from the vehicle. Bechtel further stated she heard additional shots after Brown's vehicle struck the tree and as officers approached the vehicle. The fourth civilian to give a statement was Amber Santiago. Ms. Santiago stated she was in a relationship with Mr. Brown and stated they had a telephone conversation the night before where Brown stated he believed the police were following him. Ms. Santiago further stated that Mr. Brown said he was going to stay at a hotel rather than staying at his residence at 421 Perry Street. The weapons used by the 3 Pasquotank County deputies who fired were 2 Glock 17 handguns and an AR-15 .223 rifle. These weapons were seized and provided to the SBI. The SBI recovered 14 spent shell casings, 9 from the Glock 17 handguns and 5 from the AR-15 rifle. These 14 spent shell casings were recovered from the cement driveway and in the yard adjacent to 421 Perry Street. These 14 shell casings were consistent with the body cam videos and physical examination of Brown's car as being fired by the deputies. On April 21, 2021, Mr. Brown's body was transported to the medical examiner's office in Greenville, North Carolina, where an autopsy was performed. The autopsy was conducted by Dr. Karen L. Kelly, a forensic pathologist of the medical examiner's office at the Brody School of Medicine in Greenville, That was done on Thursday, April 22nd, 2021. The autopsy was witnessed by Special Agent Cowan with the North Carolina SBI, and a written report was produced of the findings. Although the autopsy and toxicology reports have not been finalized at this time, I had telephone contact with Dr. Kelly on May 12th, at which time we discussed her findings. Dr. Kelly determined Brown suffered 2 gunshot wounds, one to the right shoulder, upper arm that was non-lethal, and a second wound to the back of the head at the base of the skull near the hairline. There were 3 bullet fragments recovered from the wound to the back of the head. Dr. Kelly found multiple abrasions on Brown's right arm, right leg, and on his back. Dr. Kelly advised me that these injuries were superficial and appeared to be made by shrapnel. Additionally, Dr. Kelly recovered a plastic baggie containing an off-white, rock-like substance from inside of Mr. Brown's mouth. The substance is consistent with crystal meth and was the size of a 50-cent piece and too large to swallow. Dr. Kelly determined the cause of death to be multiple gunshot wounds. The deputies involved in the shooting incident have no prior excessive force complaints. The law is clear and long established. The United States Supreme Court, the Fourth Circuit Court of Appeals, and the North Carolina appellate courts have all held that where officers are attempting to make an arrest, deadly force may be used if it appears to be reasonably necessary to, first, protect against deadly force that the arrestee is using to resist arrest, or 2, to take into custody a person who presents an imminent threat of death or serious injury to others unless apprehended immediately. The North Carolina General Assembly has codified this case law in our general statutes at NCGS 15A 401D2, which I have attached to the press package. The United States Supreme Court has cautioned prosecutors may not employ the 20/20 vision of hindsight, but must make allowance for the fact that police officers are often forced to make split-second judgment in circumstances that are tense, uncertain, and rapidly evolving. The law authorizes an officer to take preemptive action and use deadly force to prevent death or serious injury to himself or herself, provided that the threat assessment is reasonably made. Whenever officers use deadly force to defend themselves or to stop a dangerous fleeing felon, the determination of whether they properly used that force focuses on whether the totality of the circumstances as they appeared to the officers at the time of the killing were sufficient to create a belief in a reasonable person standing in their shoes that such force was necessary. In short, assessing the reasonableness of the shooting requires examining the perspective of a reasonable officer on the scene. Consequently, my focus was on the relevant set of facts a reasonable officer in the deputy's position would have experienced. When weighing the degree of force used, a prosecutor must pay careful attention to the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. Using these parameters, I find that the facts of this case clearly illustrate the officers who used deadly force on Andrew Brown Jr. did so reasonably and only when a violent felon used a deadly weapon to place their lives in danger. First, when assessing the severity of the crime at issue, Andrew Brown Jr. was being served with 2 felony arrest warrants and a search warrant. The law enforcement officers were duty-bound to stand their ground, carry through on the performance of their duties, and take Andrew Brown into custody. They could not simply let him go, as has been suggested. Additionally, Brown engaged in dangerous felony-level misconduct as he attempted to flee from law enforcement officers. The decision to flee which Brown made on his own, quickly escalated the situation from a show of force to an employment of force. Brown's precise speed in attempting to flee and striking Deputy Lunsford is uncertain, but that he drove recklessly and endangered the officers is not uncertain. Therefore, I find that Brown's actions and conduct were indeed dangerous by the time of the shooting. Second, Brown was actively resisting arrest and attempting to evade arrest by flight before, during, and after the shooting. All officers had been briefed on Brown's previous interaction with law enforcement, including his propensity to resist and barricade himself. Briefings also informed these officers of Brown's prior criminal history and the fact that he has attained the habitual felon status. Brown acted consistent with law enforcement intelligence and actively resisted arrest and attempted to flee. Third, and most importantly, Brown posed an immediate threat to the safety of the officers and others. Mr. Brown's conduct did not merely risk injuring officers by the time of the shooting. Brown had made 2 aggressive driving moves which caused his vehicle to contact Deputy Lunsford on both occasions. When the officers approached Brown with their guns drawn, his response was to maneuver his car and flee. Brown was undeterred by the officers yelling for him to stop, show me your hands, or by Deputy Lunsford attempting to open the driver's door. Even after backing into a corner with no escape, but to maneuver his vehicle directly at the officers, Brown continued the felonious assault by using his vehicle as a deadly weapon and made contact a second time with Deputy Lunsford. Law enforcement officers, particularly Deputy Lunsford, were on foot and directly in the path of the vehicle being operated by Brown. Lieutenant Judd was located on the corner of Roanoke Avenue and Perry in a white unmarked Crown Victoria, and Dare County officers Sergeant Ruth and Investigator Johnson were operating unmarked vehicles in the area to assist. All of these officers were potentially at risk from Brown's operation of the vehicle. Brown threatened the life and safety of the officers on the scene and any possible civilian bystanders, giving a reasonable officer a compelling reason to end the encounter. The law does not require officers in a tense and dangerous situation to wait until the moment a suspect uses a deadly weapon to act to stop the suspect. The shooting of Brown was justified to prevent potential harm to those living near where the incident occurred, as well as other pedestrians, support deputies, and the deputies who were in front of Mr. Brown. Law enforcement officers are required to instantaneously evaluate and employ force against possible criminal suspects to thwart apparent dangers to citizens and themselves. Officers must perceive, evaluate, decide, and then act, often in a matter of seconds. The deputies in this case perceived a threat and immediately fired their weapon to neutralize the threat. The perceived danger to the officer must only be apparent, not actual, in order to justify the use of deadly force. Apparent danger is such that it would cause a reasonable person to believe that he or others were in danger of death or great bodily harm. Although there is evidence of actual danger to the officers, under the law there was also apparent danger. From the evidence, it reasonably appeared to the deputies there was a sufficient basis for self-defense and defense of others. The facts in this case demonstrate the presence of apparent danger to the officers. An officer may exercise such force if he believes it to be necessary and has reasonable grounds for such belief. An officer acting in self-defense is presumed to have acted in good faith. Federal courts have held that the Constitution simply does not require police to gamble with their lives in the face of a serious threat of harm. As the United States Supreme Court has observed, the calculus of reasonableness must allow for the fact that law enforcement officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. From a review of the body camera video from the scene, there is evidence that multiple shots were fired in rapid succession by 3 deputies. There is no evidence that the number of shots fired by the deputies was excessive, but even if there are an excessive number of shots, the question is whether the perceived threat has been neutralized for the safety of law enforcement officers present. In this case, the deputies used the amount of force deemed reasonably appropriate by them to neutralize a perceived threat. Based upon my review of the facts of this case, I have determined that the shooting of Andrew Brown on April 21st, 2021 was justified to protect the safety and lives of the deputies on the scene. The deputies who fired the fatal shots perceived an actual and apparent threat, evaluated the situation in seconds, decided, and acted. The deputies' actions appear reasonable under all the circumstances of the case. The deputies faced both actual danger and apparent danger as perceived by them on the scene. This apparent threat was reinforced by Brown's dangerous and felonious use of a deadly weapon. As tragic as this incident is with the loss of life, the deputies on scene were nonetheless justified in defending themselves from death or great bodily injury. There is insufficient evidence beyond a reasonable doubt to show that any of the deputies acted in a manner that was inconsistent with their perception of an apparent threat. In fact, my review of the incident indicates there is no evidence that the deputies who fired the fatal shots acted in any manner that is inconsistent with the threat they perceived, and certainly no evidence that the deputies acted in any way contrary to or in violation of North Carolina law. I appreciate the investigation by the North Carolina State Bureau of Investigation's District Field Office. I have shared this conclusion with Sheriff Tommy Wooten and Special Agent in Charge Mache Rogers that no officer will be criminally charged. The officers' actions were consistent with their training and fully supported under the law in protecting their lives in this community. Confrontations between police and citizens in which deadly force is used are among the most important cases the District Attorney's Office will ever handle. My prosecutors and I have a duty to objectively analyze the totality of the evidence and circumstances, and that means we must face difficult issues which have been discussed at length in this report. It is my sincere prayer that no one is ever killed by law enforcement. But I also pray that law enforcement are never placed in the position of having to make the decision to use lethal force to protect themselves or innocent lives around them. I want our community to understand that this office put significant effort into ensuring that this decision was based on the facts, the evidence, and the law, and not on public opinion. In describing the legal analysis and the basis for the decision in this case, I find myself, unfortunately, in the position of correcting misinformation that has been shared both on social media and in the news media. People made claims on camera that were knowing falsehoods and were directly refuted by the body camera video. The public might then wonder why more information was not released to refute these untrue statements. I have always asserted that my office would strive towards transparency, but I need everyone to understand that among my highest priorities is also protecting the integrity of every investigation. Releasing information before any investigation is complete can taint the case. Preventing an objectively verifiable investigation and perhaps even the possibility of prosecution. In an ongoing investigation, details are closely guarded to help measure the truthfulness of witnesses and, should someone be charged, preserve the defendant's right to a fair trial. I know that a lack of accurate information is frustrating to the public and the media that operate on a 24-hour news cycle, but in this age of instant media and the impulse to immediately form an opinion, I'm asking that as we move forward, we remind ourselves that in these cases, we should not jump to conclusions until all the facts are out. I will always be guided by my oath of office, by the United States and the North Carolina Constitution and the North Carolina General Statutes. Justice demands nothing less. Thank you. Yes, sir.
Do you think all the facts?
You're listening right now to Andrew Womble. He is the Pasquotank County DA. He's been speaking for roughly 40 minutes now, saying the shooting of Andrew Brown Jr. was justified by his deputies, says the information leading to his arrest was based on, in his words, a reliable confidential source calling Brown a known drug dealer. Let's get right now to our own Dr. Laura, our chief legal analyst here at BNC. Dr. Laura, the first thing that I thought about when I heard him talking was that if you throw a lot of crap at the fan, it doesn't make the room smell any better. And we go back to the beginning. If you believe that the officers didn't do anything wrong, why not release the body cam videos 3 weeks ago? Because that's what the transparency was supposed to be about when police were armed with body cameras, correct?
Correct. And so I'm still not understanding, after actually seeing the body cam footage myself, Dale, why they didn't just release this in the beginning, why they didn't release this the same day the family saw the video. Very troubling. And, you know, I keep looking at this video and I'm struggling with the sense of knowing what the law is in terms of under what circumstances officers can use deadly force, and also recognizing there's an element of choice here, and there's a different set of choices those officers could have made. They could have let Andrew Brown Jr. drive away and try to, you know, obtain him later at a different time, catch him surprised walking out of the grocery store. He wasn't intentionally trying to hit them. That is very obvious with that vehicle. But the problem is the way the law is set up. It's set up to look at what the officer's objectionable perception is. What is their perception at the time of the event? Was it reasonable, considering that they were serving 2 felony warrants on a person who's had previous interactions with the law? Was it reasonable, considering in the past, you know, that he's barricaded doors? Was it reasonable that this officer, although he was able to get out of the way, he could have been hit with the car as Andrew Brown Jr. was trying to flee? And that's where it gets a little iffy. There's a Supreme Court case that's well understood, Tennessee versus Garner, that says that officers cannot use deadly force on a fleeing felon unless it puts their lives or the lives of others in danger. And that's what's different about this case as opposed to George Floyd. Clear-cut case. We saw he was handcuffed on his stomach, not putting any officers at risk. Eric Gardner, not putting any officers at risk. The facts in this case aren't as cut and dry.
Dr. Laura, I am no bleeding heart liberal by any stretch of the imagination. I have actually been on raids with sheriff's deputies in North Carolina and also in Kansas City and places like New York. But the difference this time is this. Small towns like Elizabeth City, population 18,000, there is a battle that goes on between sheriff's deputies and the people they perceived as being the bad guys. In this case, something that really struck out to me was that he said, "We saw Andrew Brown earlier in the day and we chose not to make an arrest then." I was on Capitol Hill on January 6th. They chose not to make arrests then. 400 people have now been arrested. Not a single shot has been fired. I think the producers are telling me right now they want to go back to the news conference. We'll get to this question on the back end. Let's take a listen.
So can we get this clean? Can the media get the video you had in the presentation?
Any other release of this will be done through the courts.
It just,
Okay.
The question he was asking you about the use of
Have you
force.
set a date, a hearing date, or have you spoken to the judge about a hearing date for when there might be a release or discussion of a release?
No.
Have you asked for that?
I have not.
You
Mr.
plan to
Womble,
ask for
can
it?
you
No,
tell
sir.
us, are all 7 deputies back on the job?
I cannot answer that. I do not believe that all 7 deputies are back on the job,
Are there any
but I
internal
cannot
reprimands?
tell you that for sure.
Any internal reprimands for them?
So you're asking me this question, and I'm sure for the benefit of everyone else. I don't have anything to do with the Sheriff's Office internal investigation. I'm not responsible for whatever administrative and or civil actions come after this. I'm only responsible for the criminal side. So I can't speak intelligently to the question that you're asking, whether there will be any further administrative proceedings after this.
You talked about falsehoods in the way the video was portrayed. Why do you think that is? I mean, it is hard to look at these videos and see exactly what you're explaining unless you watched it multiple times and maybe somebody's actually explaining to you where everybody is located.
Sure.
I mean, do you think it's perception? You know, I mean, obviously that's something you're very concerned about.
Do I think that people can see what they want to see? Absolutely. I would hope that attorneys, licensed attorneys, who are bound by the same oaths and the same rules of professional conduct that I am would conduct themselves a little differently. Family members who are grieving, who deserve our sympathies. Sure, I can, everyone can perceive something differently. And until you break it down frame by frame, some of the actions are pretty hard to see.
Is your opinion then that the Brown family attorneys deliberately or intentionally?
I'm not saying that. I'm saying that there were falsehoods made. You can draw whatever inference you want. Hang on one second.
Just to try to put a button on this, we saw the video, and it definitely appeared that Mr. Brown was trying to get away and not going directly at any officer that we just saw. Is there something else that maybe you have seen to help you come to that conclusion other than what you showed us today?
Okay. Let me ask you this.
The wheels were turned away from the officer.
Did you see the officer put his left hand on the hood of that vehicle?
Yes. As the car was turning away, Mr. Womble?
Yes. Did you see the tracks in the dirt?
Yes, sir.
Okay. If that car is on pavement, that officer is run over.
Can you replay the video?
But the car wasn't.
I'm not going to.
What do you say?
I'm not going to replay it.
Protesters that may feel like these officers could have moved out of the way in this scenario. I know a lot of protesters may be taking the streets after this. So, what do you say to them in this situation?
That's not the officer's duty. The officer's duties were to take Mr. Brown into custody. They simply couldn't let him go.
And just in other scenarios, people have seen people be let go, and in this situation, I know you're saying he couldn't have been let go. Couldn't have been let go, and you got him at another time in a less dangerous way by chance. Do you believe?
Are we dealing in the theoretical at this point?
No, we're just trying to make sure that, I know you're trying to say what these officers did, they had to get him at this exact time and moment. But could they have moved out of the way instead of getting hit by a vehicle?
I think they did move out of the way. At least Deputy Lunsford moved out of the way, but he had to take evasive action to do so.
I have a follow-up to that. I mean, you said earlier that they had a duty to carry out the warrant, that they had to take him in. Can you elaborate on that, though? Why couldn't they have let him go in that moment and followed up later?
Law enforcement officers are duty-bound the same way, well, not exactly the same way, but in the sort of same fashion that I'm duty-bound by oath. That was their job on that particular day. They had a judicial warrant. They had an officer telling them to take Mr. Brown into custody. So Mr. Brown's response to that was to flee.
I understand that, but
so what you're asking,
even if it requires,
what you're asking is that law enforcement not act upon the judicial directions of a search warrant and give way to citizens when they decide they don't want to be taken into custody.
Why not catch up to him later?
Why not take him in right then?
Because it was clearly a volatile situation. Why not catch up to him later?
And it would have not have been volatile later.
Also, when he was escaping, have officers taken into consideration that people around the situation, the houses, because everybody gets the bullets going in the houses as well.
Yes, that's why they attempted to do this the night before, and they wanted to do it the night before and take him into custody when he was in the house. They anticipated when they left that Mr. Brown, when he pulled up beside the car, would actually go inside, but he never did. He stayed in the car.
No, I meant when he was fleeing away, the officer still shot. How do you justify that as he's fleeing away from the officers? And the officers were kind of putting everybody else in danger while shooting towards the other houses.
And I would say that Mr. Brown was putting everybody else in danger as well.
You said there were 14 spent shell casings. Did
Correct.
all of them hit the car or Mr. Brown, or were there some scattered throughout the neighborhood?
There were 14. There were a total of 14 on the vehicle. There was one shot that we believe ricocheted and was and found in a house.
In a house?
Yes, correct.
Did you ever consider, I know there were calls from the attorneys for the family of appointing a special prosecutor Did you ever, were you concerned that you might be too close to these deputies, that you work with them on a regular basis? I mean, did you feel confident that you could handle this investigation and not be biased?
Absolutely. Absolutely. I'm elected by the people of the 1st Judicial District to do exactly this job. A special prosecutor or outside counsel is not accountable to the people of this judicial district. I am.
But that is an independent view of this.
You made a point of saying that you're not taking the public opinion into account here, that you're just simply weighing things on the fact. Why bring that up? Do you feel like public opinion turned against you here?
No. I want to make sure, I want the community to completely understand that the right to protest is certainly important. The need for information is important. The transparency aspect, accountability of my office. But in these particular cases, I am basing the decision on the facts, the evidence, and the law, and nothing else.
Have you spoken to Andrew Brown's family about your decision today?
I have not, and that is unfortunate. It's not the way that I would normally want to do this.
Why did you?
Our original discussions immediately after this occurred with Mr. Brown's attorneys did not go well. We tried, or there was a second meeting with the family in which the attorneys were not present. Obviously, any party that is represented by counsel, I have to be very careful in dealing with attorneys before I deal with parties. I was unable to do so, and at this point, the relationship is just constrained to the point that I did not speak with him. I'll be happy to talk with him at length after this is over. Yes, sir. This man has been very patient. Okay.
Specifically, the part where he's driving across the field towards Roanoke Avenue.
Yes.
For the officers to continue shooting at that point, in your mind, why is that justified? Is it because the unmarked vehicle was across the street on Roanoke Avenue, or was it because they could keep shooting because of the additional incident in the driveway?
It is both. So once a threat is perceived, and our case law is very clear on this, once a threat is perceived and the officers fire the first shot, if the first shot is justified, the last shot is justified until the threat is extinguished. That is the Plumoff versus Rickard case. It's a United States Supreme Court, and it is clear. In the Plumoff case, the officers fired 3 shots into a stationary vehicle. The vehicle then backed away from officers and sped down the street, at which time they fired 12 additional shots at the vehicle as it sped away, and there were no police officers anywhere in the direct path of that vehicle. Supreme Court found the officers' actions in that case were reasonable. They said they weren't even close to being unreasonable, and they did not find even a Fourth Amendment violation. There has never, ever in our American jurisprudence, the Supreme Court has never found a Fourth Amendment violation when a suspect uses a car as a deadly weapon. Never. Not one. Hold on. Wait a minute. Wait a minute. One more time in the back. Yes.
Is the car being used as a deadly weapon no matter how fast it was going, just because it was moving in the direction of the officers at some point? It doesn't matter whether it was accelerating just to put off the gas?
Yes, in my opinion, at this point, it was employed as a deadly weapon. Now, are you asking me theoretically what, in other cases, can we possibly...
Just in general, it doesn't matter what speed it was going. If it was at all in the direction of...
Yes. There are several cases where officers have instructed drivers to shut the car off. The car is stationary. And the simple act of starting the car in violation of an officer's command makes the car a dangerous, deadly weapon that can be used at that point, and officers can shoot. Yes, ma'am, in the back.
As the car was exiting the neighborhood, as you say, it was driving towards some unmarked sheriff's vehicles. Several of the protesters, and we've heard comments that the area that we were in, or excuse me, that they were in, was a school zone, and it's 8 o'clock in the morning, and after 8. Was there any consideration into that of the extended neighborhood in being in a school zone?
So the officers in their comments did not talk about the extended school zone. Certainly, when I get the leisure, they're acting in the heat of the moment, and I'm looking at it in the cool of the night, so to speak. Certainly, I would think that Mr. Brown driving this vehicle, operating it in this manner, in this particular instance, could put the lives of school children in danger? Absolutely. That was not listed in the officer's notes.
To clarify, did you get a court order to release this body camera video today?
No.
Isn't that in violation of the statute that requires a petition and public hearing?
Statute applies to the custodian of the records. I am not a custodian of the
So
records.
can you clarify the use of...
Hang on one second. Yes, ma'am.
Was it your perception that Mr. Brown intended to threaten the officers with the car, or does that have any bearing on your decision?
Was his intention to threaten the officers with the car? That requires me to speculate as to Mr. Brown's intent. I think Mr. Brown's intention was to get away. I think Mr. Brown was fleeing an arrest because Mr. Brown had drugs on his person and in his car, and I think he did not want to get caught with those. So that's why I think Mr. Brown was fleeing. The officer's position around the car is why he drove at them. He had no choice. If he was going to attempt to flee, he had no choice but to drive directly at the officers. When he did that, and he made that decision on his own, he placed their lives in danger.
So had he fled and not had deputies in the path, would that have been relevant to your determination in this investigation?
I can't, once again, as we're moving into a theoretical discussion, yes. If there were no deputies in the path, I think I could have looked at this differently. If you will see, when the car backs up and Deputy Lunsford is pulled off of his feet and onto the hood of the car, that aggressive driving moment right there, in my opinion, is a threat to the officers. I believe that they would have been well within their rights to shoot at that moment.
At that point, Brown has used the car as
a deadly weapon. Absolutely.
To clarify again, when he backs up, you said Officer Lunsford's body was pulled to the hood of the car. Were there any deputies, officers behind the car in the direct path of the car as it backs up?
No.
It's not clear.
No.
And he doesn't. Lunsford is the only deputy that he makes contact with when he backs up.
Yes, that is correct. Deputy Swindell was to his right.
Can I ask a follow-up to that question? Because that's important. You just said he threatened the officer, but he's backing away from the officer, and the officer is going toward him. So he's trying to avoid the officer.
You do understand that he was going to be arrested and taken into custody that day?
But he was backing away. I'm just going off of what you're telling us here.
Okay.
You're sending these mixed messages. You're saying he was threatening them, but then he's backing away, and it's the officer going for the car.
Okay, when you employ a car in a manner that puts officers' lives in danger, that is a threat. And I don't care what direction you're going. Forward, backward, sideways. I don't care if you're stationary, and neither do our courts and our case law. Yes, sir.
I'm just wondering, if you had any interviews with these deputies, did they express their fear, or in their interview, were they saying, "Yeah, I felt like I could get run over"? Did they ever say anything for some of that stuff?
Yes, they did, but not to me. I did not interview the officers. The State Bureau of Investigation did the interviews, and I read the reports, and yes, they all stated either they were afraid of being run over or they were afraid of their fellow officers being run over. Yes, ma'am, and I'll get it to you in just a second. Yeah.
You mentioned you can't use the court of public opinion when making these decisions, that it has to be based on the facts. But yet you live in this community. This is your community. Are you concerned at how this decision will be received? I mean, we can already hear protesters outside. We can assume that it will not be received well. I mean, is that a concern?
So I believe that there will be folks who are not happy with this decision. When I was appointed the district attorney in 2013 and then ran for this position in 2014 and ran for this position in 2018, I had a full understanding of what the responsibilities and duties of the district attorney are. Sometimes I make popular decisions, such as charging the 4 inmates in Pasquotank County with capital murder. That was a popular decision. And I make unpopular decisions, and I signed up for all of them, the popular ones and the unpopular ones. Wait a minute. Thank you.
The 4 videos you showed us, were they included among the videos that the family saw?
Yes. The family actually saw a longer version of the 4. I did not include the portions where law enforcement removed Mr. Brown from the car. I did not think that there was any journalistic need for that. It's clearly, he's clearly in a lifeless position. Yes, sir, in the back.
Tim from ABC 11. Have you been in touch with the FBI about their investigation?
No, sir, I have not. The FBI sent a letter to my office very early on requesting the body cam videos. I believe that I know that they have them. They did not get them from me. Sorry, right here in the middle.
Mr. Brown was driving toward an unmarked van that had a law enforcement officer in it while the Pasquotank officers were shooting toward Brown's car. Obviously, his car passed very close to the unmarked van. Were the shots fired by the sheriff's deputies ever putting the other law enforcement officer in the unmarked van at danger?
He's clearly in front of that car. The body cam, because of the lens, actually distorts the distance between the officers and the vehicle as they're shooting. It's really not that far away. Were they really in danger? No. Were they in the path of bullets? Yes.
Can you clarify which officer fired the fatal headshot which killed Andrew Brown and how far away that officer was at which angle?
I do not know that. Let me explain why. The bullet that was removed by Dr. Kelly from the back of Andrew Brown's head fragmented. So what that means, according to Dr. Kelly, is that the bullet was tumbling when it struck Mr. Brown. It was tumbling because it was knocked off his path either by a headrest, glass, or some other object inside the car. When it tumbled and hit Mr. Brown in the back of the head, it then splintered into 3 pieces, making it impossible to determine from what weapon it was actually fired. Now, a metallurgic study could possibly figure that out. It's not relevant to my decision, and I didn't need that information. Yes, ma'am, on the way back.
Yes. So you said before that the intention was to arrest Mr. Brown. But in the 14 shell casings that were found, that were spent at the scene, is there any question in your mind to whether or not why deputies would shoot directly at someone's head in a vehicle rather than surrounding the vehicle to potentially stop the vehicle and take someone into custody? If that was their intention to bring him in custody.
So once again, I believe at this point we're discussing hypotheticals or theoreticals. Mr. Brown's vehicle shows multiple shots into the side of the vehicle. There is the one shot in the front windshield that came from Sergeant Meads, and then there's several in the back windshield as the car is moving away. So there are several shots into the body of the vehicle itself from a very close distance. One could think that that was to disable the vehicle. Was that question asked? It's not in the officer's notes. It's not in there about what they were trying to do other than extinguish a threat.
Will any of those officers' notes be in the information that you're releasing today?
No, ma'am. And that file within my office will stay within my office. That is our policy. I do not release any files because they're not public record, and that is our stated policy here. I'm doing this only because of the obvious notoriety of this particular case. Man in the back.
So at what point did you determine that he was using the vehicle as a weapon? Was it when the deputy's arm was on the hood of the car or when he put the car into drive?
You're asking me at what point did I make that determination?
Yes.
So once again, the standard of what I need to look at is what a reasonable officer on the scene would have perceived, not necessarily what District Attorney Andrew Womble would perceive. But I'm going to answer your question. Your question is, when do I think he employed the vehicle as a deadly weapon? I believe he employed it as a deadly weapon the moment he did not respond to officers' commands to show them his hands and get out of the car. When he used the car in contravention of their commands, at that point he has demonstrated his willingness to use that vehicle in any manner he deems necessary to evade lawful arrest.
Sure. I think that for us in the national, this case especially highlighted the North Carolina law regarding body camera.
Yes, sir.
I think it's also fair to say that video evidence has kind of changed law enforcement and how you're able to examine cases. I wanted to see your perspective of the North Carolina law regarding the release of body cameras. Was it useful for your office in this case? Is it a useful law? Would you like to see any changes?
You know, this was the first opportunity that I've had to deal with this particular body cam statute. For the purposes of the district attorney's office and what my duties are in all investigations, all criminal investigations, I found the statute to be very useful, very purposefully written, very useful. It gives an opportunity for anyone who's depicted to have an opportunity to view that, and I think that is important. Could that have been done earlier? Possibly, but once again, the statute dictates how petitions are to be filed and requests are to be filed and how they're supposed to be made. I'm not going to get into whether that was done early on and in the right manner in order to allow the sheriff to make that early disclosure to the family. But with respect to criminal investigations, my job, as I stated, it is of the highest importance. I have to protect the orderly administration of justice in all cases, and that's mass murders. That's whether it's law enforcement being investigated. That's sexual assault cases. That's breaking and enterings and petty larceny, and it doesn't matter. So that is my job, and I take it very seriously, and that is why I took the position that I took with regard to this, and I will take it in every instance that involves body cameras or other law enforcement cameras. I want to see it. I want to conduct my investigation. I want it done correctly without the taint, without the possibility that other people have seen it and are now going to interject things that we cannot objectively verify again. I want that investigation done properly.
I think
that protects everybody involved, not only victims, their families, but potentially the people charged.
I think some of you that statement as you don't necessarily want to have the sunlight come to these kind of events and to the public. In your state, not necessarily, but the public to see these raw events and make their own determinations.
I'm not following. You're attributing something to me. What did you say?
Some people might feel that what you just said is that you may not necessarily want the sunlight to open up these videos to be out in the public place before an individual like yourself is in a determination capability once they've done their investigation. Am I attributing what you say wrong, or?
No, I think that is correct. I think I brought it today for the purposes of accountability and transparency. I think, as I said before, and I believe I said this at the hearing, you will get an opportunity to see it. The public has a right to see it. Our courts are open. Our Constitution says that the courts in this state are open. So in one of two ways, this would have been exposed. Either I would have exposed it in a court while at trial, and you would have had to wait, or I can expose it today because I'm not bringing any criminal charges. Hold on one second. I'll come right back to you, I promise.
Thank you. Can you clarify when deputies were hit, what part of their bodies were hit, and whether there were any injuries sustained?
I cannot clarify whether there are any injuries sustained. I do not know that. Deputy Lunsford was struck. From the video, it looks clear to me he struck up the entire left side of his body. I cannot tell, and it does not indicate in his statement whether the car rolled over his foot. He clearly yells. You hear him yell when the handle is snatched out of his hand. He loses his balance. Deputy,
when he was struck during that?
That is correct. That is correct. He struck up the left side of his body, and he moves his left leg out of the way. And yes, his upper body is pulled across the hood of the car.
Physical contact?
No. The second physical contact is when the car is moving forward. Deputy Lunsford then puts out his left hand to brace himself and spins his left leg again up and around to get out of the way. I come back to this gentleman.
Mr. Womble, you talked about the relationship with the attorneys for Andrew Brown's family. Could you talk about, you called it difficult. You said you had to be careful. What did you mean by that? And with you admitting that, your job is difficult, you take on the tough cases, why not do more to try to reach out and communicate with those attorneys? Because they are speaking to the masses, if you will, but we're not hearing a lot from you. So why not try to, really spend some time with the attorneys, talk about that relationship and the problem that you say there is there.
So we had a meeting very early, possibly the second day, maybe April 22nd, with attorneys involved in the case. After I met with attorneys, they held a press conference and disclosed information that we had a discussion. It was my belief that that conversation was going to be private between us, and we were going to have a working relationship. Once the rules of the game changed, then I knew I had to protect the integrity of the investigation and keep the information that I had within my office. Attorneys in this case who are purporting to represent the family aren't licensed to practice law in this state. So in order to represent someone in the state of North Carolina, you must either be a licensed attorney in this state or admitted pro hoc vici. To my knowledge, there were several attorneys who were purporting to represent members of the family who were not either one of those things, either licensed attorneys or admitted pro hoc vici. So I can't discuss with them. And third, when I have an ethical obligation not to deal with someone that I know is represented by counsel without dealing with counsel. So that put a barrier between myself and the Brown family. One that I think, in all honesty, we could have done a better job to repair that relationship prior to this. And it's unfortunate, and I don't like the way that played out. Yes, sir.
The Pasquotank County Sheriff's Office has a use of force policy regarding moving
Yes, it does.
vehicles. I'm looking at it now. It says shots fired at a moving vehicle involve additional considerations and risks and are rarely effective. When feasible, deputies should take reasonable steps to move out of the path of an approaching vehicle instead of discharging their firearm at the vehicle or any of its occupants. Did that play any role into your decision today, and were you aware of that?
I am aware of it. I have a copy of it, and no, it did not. In the back.
To what I asked earlier, you said the duty of the officers was to arrest Brown, which is why they couldn't move out of the way and let him go in this situation. Have you seen other situations where officers were going to serve a search warrant and they let that person go because the situation got too dangerous or because they couldn't arrest him at that time?
No, right off the top of my head, I cannot.
And why did you not?
I cannot think.
Was that not a part of your decision? The law that I think Zach just mentioned about.
That's an administrative policy. It's not part of the criminal statute and what I need with respect to determining criminal liability or criminal negligence. That's administrative only. Yes, sir, in the back.
Just to clarify, and this might be an obvious question for you, but if anybody's unhappy with your decision today, is there any other recourse or redress that they have, or is this it?
The ballot box.
And we're continuing to follow.
You've been listening to Andrew Womble. He is the DA in Pasquotank County, North Carolina. He is talking about the decision not to charge any of the 7 officers involved in the shooting death of Andrew Brown Jr. Dr. Laura, before we cut away to the news conference, the Q&A with reporters, I asked you the question about proportionality in this particular case, pointing out that yes, they believed that he was dealing drugs. Yes, there were 7 officers who approached him. But as an African American, we see these scenarios play out in small towns like this where it's the good guys versus the bad guys pulling up, and then something goes terribly wrong. And Black America keeps asking the question, did it have to be this way? When we look at the January 6th insurrection and see that no one died as a result of that, with the exception of one person, and all 400 and some people that were arrested later were arrested days, if not weeks later.
Yes, and so, Dale, no, it didn't have to be this way. And I keep thinking of all the times I've seen video footage of white men with actual guns fleeing from police trying to apprehend them, and they're allowed to drive away. They're not shot in the back of the head. And so there's still this double standard that we talked about extensively during the Derek Chauvin trial. We'll be talking about it, unfortunately, during the Daunte Wright trial that applies to Black America. And that's the issue I'm having here. The standard of wasn't objectionably reasonable. That is the legal standard used to determine whether or not these officers' acts were justified, is ripe for opportunities for bias, different set of rules depending on who you are. And so that is my biggest issue with this, and something just doesn't smell right here with me, Dale. The fact that they still won't release the body cam footage. They gave us a fast forward version of the video. I'd like to see it slowed down, the opportunity to look at it several different times. When you have something like this that's really based on a factual determination, let the jury decide whether or not it was justified under those circumstances to shoot Andrew Brown in the back of his head. The fact that they're still holding on to evidence and not releasing it to the public, something's not right here.